Hello, and welcome to Williams Mullins Benefits Companion, a podcast that helps employers navigate the complex legal challenges of managing their employee benefit plans. I'm your host, Bryden DeWitt, and today we'll be discussing recent COBRA notice litigation. You may be wondering, why are we discussing COBRA? COBRA is pretty settled law. We've had COBRA requirements around for decades, and we use model Department of Labor notices. So why is there a podcast in 2021 on COBRA notices? And the reason is that in 2020, we saw a wave of litigation regarding COBRA notices. Many of these lawsuits have settled. One case in 2020 settled for $1.6 million. So it's time to dust off the COBRA notices and make sure that the plans are in compliance with all of the COBRA requirements. And so briefly, to review the various COBRA requirements, there's a general notice of COBRA rights that must go to employees and their spouses within 90 days of being covered under the group health plan. And this notice may be included in the summary plan description. And then there's a qualifying event notice from the employer to the plan if there's a reduction in hours or termination of employment that causes an employee to lose coverage, or the death of the covered employee, or the covered employee becoming entitled to Medicare, or the employer's bankruptcy. Within 30 days of those events, the employer has to provide a notice to the plan administrator. Often the plan administrator and the employer are basically the same entity. And then there's a COBRA election notice that must go to the qualified beneficiaries, to the plan participants who are impacted by a loss of coverage that's due to a COBRA qualifying event. That notice must go to the plan beneficiary within 14 days of the notice from the plan sponsor or from the employer regarding the occurrence of an event. So basically, the deadline is 44 days from the occurrence of a qualifying event from the date an employee loses his or her employment or has a reduction in hours and loses coverage under the plan. The employee has to receive an election notice. And the regulations provide a laundry list of information that must be included in a proper COBRA election notice, that information that's necessary to allow the employee or the former employee to exercise COBRA rights. So information like the name of the plan and the name and address of the COBRA administrator, the identification of the COBRA qualifying event, the identification of qualifying beneficiaries, an explanation of the right to exercise COBRA, to elect COBRA coverage, the deadlines, how long COBRA will last, or what are events that could cause COBRA to terminate early. Various information like that that really gives the employee information necessary to understand COBRA rights. And then there's a notice of unavailability of COBRA coverage if someone wants to apply for COBRA, but it's not available to them. And then if an event occurs that would cause COBRA to terminate early, there's a notice that has to go out if that occurs. And so there are penalties that the Department of Labor may assess and the IRS may assess if an employer fails to satisfy these COBRA notice requirements. The Department of Labor may impose a civil penalty of up to $110 per day per person, and the Internal Revenue Service may impose an excise tax of $100 per day per beneficiary and $200 per day per family. And it's this Department of Labor civil penalty that is the focus of these class action lawsuits. And so if you think about a plan with thousands of participants, and then this potential of a $110 per day per person penalty for failure to meet the COBRA notice obligations, the numbers add up. And that's where you get to that settlement in 2020 where an employer settled a case for $1.6 million. So there are a couple of law firms in Florida, plaintiffs' law firms, that have filed in 2020 over 20 lawsuits alleging really technical and ticky-tack violations of the COBRA election notice requirements. These lawsuits even involved employers that use the Department of Labor model COBRA election notice. So even if you're using the model notice, it doesn't mean that you're bulletproof, that your notice can't be challenged, and that this lawsuit, probably seeking a settlement, wouldn't occur. And so these lawsuits claimed that there was a failure to provide the name, address, and telephone number of the plan administrator. They claimed that the notice didn't adequately describe how to elect COBRA coverage, and didn't include an election form. They've claimed that there's a failure to notify COBRA beneficiaries of the end date. The notice only provided the start date of coverage and then the duration, that for a loss of employment, the duration is 18 months. The lawsuit claimed that, well, you needed to provide the end date, not just say 18 months. Failure to provide an address for premium payments, and this was the case even when the election notice included an addressed and stamped envelope for the employee to put their premium payment in. They still claim that the notice was defective because it didn't provide the address for premium payments. Also, failure to explain the impact of the COBRA decision on future HIPAA rights. There's claims that the notices were not written in a manner calculated to be understood by the average plan participant, that the notice wasn't offered in Spanish, the failure to identify the specific qualifying event, and then also failure to comply with the Department of Labor model notice. So as you can see, they're really picking apart the COBRA election notice and the multiple requirements in the Department of Labor regulations regarding what has to be included in a COBRA election notice, and then seeking that $110 per day per participant civil penalty under ERISA, and the numbers add up. So it's really time to, again, dust off the COBRA notices. If there's a COBRA administrator that's being used, to talk with the COBRA administrator and really take a look at the COBRA notices, take a look at these lawsuits and this list of items that I just listed, and make sure that the COBRA notices and procedures and timing of issuing notices are as compliant as possible with the Department of Labor regulations. So that'll wrap up our discussion about COBRA notices. If you have any questions or suggestions about future episodes, please contact me. You can also visit our employee benefits page at williamsmullen.com/employee benefits. There you will find out more about our team, as well as past episodes of this podcast and legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening.